G'day guys, it is a week before Christmas, or today it's the 19th for us, and I thought I'd just do a little intro to the next clip that I'm going to put up. Now, I don't know if you guys have been following what I do or what I don't do, or the things that I do on YouTube in the lines of challenging, the status quo or the authorities or law. What I've learned over the many years, and I've studied people like Dean Clifford, Bill Turner, all of the people that, Roger Hayes, Mark Stevens, ethical, anarchist articulated, all of the people that have been extremely helpful, considered, I suppose, gurus in their particular fields. What I've discovered is, they all have their own ways. Carl Lenz, for instance. I've tried all of these different approaches throughout the years. Fuck, all of them have worked. Which is why a lot of people say, oh, the free man of the land bullshit doesn't work, or common law this, or common law that. Common law is like a foundation. It's a principle. Statutory laws are there to clarify common law that already exists. It's something that's put on paper to clarify it and make it more understandable for the general populace. What I've found is that after trying many different avenues and different attempts of seeing if this works or seeing if that works, and this is only challenging like speeding tickets, I've found basically the Achilles heel of it all. It doesn't really matter what you do. It doesn't matter what style or theory or genre you want to try. They don't care, because it's their system. They will do whatever they meaning the hierarchy enslaving you, they will do whatever they want. And to their detriment, they tend to ignore the rules and procedures that we're all supposed to follow. They don't do it themselves, just as you see with a two-tier justice system over in the States, All the populace must follow the rules, but clearly the higher-ups like Clinton and the rest of them do whatever the fuck they like, because they don't care. They think they're above it. The same things I'm noticing with New Zealand. The cops are the ones that do all the prosecuting over here. It's not like we have a separate system. It's the police prosecutions unit or the Crown prosecutions that do a lot of the day-to-day prosecutions against the general populace. They will very rarely give you what you're entitled to. Now, most Joe Blogs out there don't know what you're entitled to. So that is why this intro is important. It's to tell you guys that it doesn't matter what style or genre that you attempt to try. The Achilles heel with the system is the fact that the people running the system or enforcing the system aren't following their own rules themselves, and that is their undoing. So all I can suggest is, because as Mike might say in regards to the matter we're dealing with at the moment, Your Honour, everybody just pays, nobody questions, and that's the problem. You're all sound asleep, acquiescing to everything, giving passive agreement. You need to stand up for yourself, or exercise what you've got before it atrophies and dies. So I'm going to show you what you should get for initial disclosure and full disclosure, and hopefully you guys will cotton on to what I'm trying to tell you. Right guys, initial disclosure. This is section 12 of the Criminal Disclosure Act 2008, and it's subtitled Disclosure by the Prosecutor. This is what the police prosecutions are supposed to supply you once you challenge or request a court hearing. At the commencement of criminal proceedings, or as soon as practical after that time, and in any event not later than the applicable date, the prosecutor must disclose following information to the defendant. Subsection AA is a copy of the charging document. And subsection A, a summary that is sufficient to fairly inform the defendant of the facts on which it is alleged that the offence has been committed and the facts alleged against the defendant. And B, a summary of the defendant's right to apply for further information. C, a maximum penalty and the minimum penalty if one is provided for the offence. And D, a list of the defendant's previous convictions that are known to the prosecutor. And E, a list of any previous offences that have been committed by the defendant of any kind to which section 284(1)(g) of the Oranga Tamariki Act 1989 applies. So that's subsection 1. So that's what you would call initial disclosure. You might note down there that it says B, the summary defendant's right to apply for further information on subsection 2. Subsection 2, it states basically at any time after criminal proceedings are commenced, or in the case of a young person or child, well, that's not relevant. At any time that a person's first appearance in youth course, the prosecutor, after that person. So basically what you have your initial disclosure, which is what you should have at the latest by your preliminary hearing or your first appearance. That's basically meaning a summary of facts. On the summary of facts, so you should put the maximum penalty on that. On the charging document, they would or should also have the provisions of, section 133 or 40 of the Land Transport Act, Rule 5.1, blah blah blah. If they don't supply you all of that stuff, then you haven't been fully informed or fairly informed of what the charges are. It also states that the facts alleged against the defendant. Well, you're the defendant and yet they clipped a car. So why isn't the car the defendant? Now, given the fact that you are automatically presumed innocent, yet in the Land Transport Act it'll say you're automatically presumed guilty of that offence unless you transfer liability. The whole point is you're not guilty of anything to begin with. Your car could have easily been loaned to a friend or borrowed or whatever. There's thousands of possibilities, and the burden of proof lies on the prosecutor to supply every element of the alleged against you. So this is the first thing they should give you. Now, the section 2, it's basically names of any witnesses. Okay, so you should get a witness list. You should get a list of exhibits that they're wanting to use, and a copy of all records or interviews with the defendant. You should also get a copy of interviews of the prosecution's witnesses as well. Okay, so that's the subsection 2. It goes on to say you should also get a copy of job sheets and other notes of evidence. So that's like the speed camera deployment registrar, the job sheets or the daily log books. A copy of any records evidence by a testing device, so your certificate of authorization. You should also get your license history. You should get there's quite a few things you should get, but all of that should be provided to you at the latest by your defendant hearing, which is your second appearance generally, and that's after you've entered a plea. However, if you strike a judge that decides to use section 39, where a defendant that's reluctant or refusing to enter a plea, the judge can then deemed not guilty plea for you to continue the matter, which is kind of what Judge Black did to me. He just steamrolled over the fact that I was asking questions about being fully informed. Then you can easily just say that you wish to have that plea struck or removed because you didn't enter it. In my case, I wasn't refusing or reluctant. I'm standing there with this plea of guilty in my hand ready to sign. That pretty much shows my intent. You can't say I was reluctant if I've already got one pre-written out. You can't say I'm refusing if I've already got one pre-written out, and I was happy to sign and settle the matter provided I could be fully informed. But I wasn't fairly or fully informed because the prosecution never gave me disclosure. And this is how this works. Section 13 is what you call full disclosure. So the standard information, which is what you get in Section 12, which is your initial disclosure documents. You should also get a copy of any statements made by the prosecution witness, brief evidence, anything that they give you say no to. They must give you the reason why they're refusing to supply something, and you also have the right to apply for the grounds for their reasoning. Okay. They have the obligation to disclose the information to the defendant as soon as reasonably practical, and if they can't do that, then there's a major problem. They're also supposed to supply you the witnesses' addresses so you can go and independently interview the witnesses. Any written account, records, statements, previous convictions of the witnesses, which is quite interesting. That's Section 13, subsection 3D. Any convictions of the prosecution witness that are known to the prosecutor that may affect the credibility of that witness. Who knows? You know, you don't know unless you ask. So there's all of these things that you should be asking for and you should be getting supplied, and if you don't, well, basically you haven't been informed and you can't continue any further. You can, under Section 14, request additional disclosure. You can, by that, you can say you're requesting information that you should have gotten under initial or full disclosure prior, but you haven't. The prosecutor can refuse and give you reasons that he doesn't have it in his possession, or that evidence hasn't existed for him to supply it. He doesn't have to create documents for the sole purpose of disclosure. However, things like a witness list, you should have gotten that right at the beginning. So if they're creating those a long time afterwards and then saying you've been given full disclosure or initial disclosure, they shouldn't be creating those documents 5 or 6 months after the fact when you should have got them at the first hearing. So there's lots of little tricks and things they'll try and do. They'll try and hand you the paperwork when you're there for your first or second appearance. I mean, if they can't get it to you before the preliminary hearing, you go ahead with the hearing first. Take the documents after you've been heard by the judge, because that way you can say you've not received it, you've asked for it, they haven't given it to you. And if they try and do the old sly, well, do you want to have these ones, and try handing them to you before a hearing, just say, no, I don't want those at the moment, thanks, I'll have a look at those later. Because you don't need to see something that's just been slipped under your nose without having a chance to review it. So if they couldn't have given it to you prior to there, so you could review the evidence, then you're not interested in looking at it just before you're about to stand in front of a judge. Yeah, they can say that you're being that their request is frivolous or vexatious. In other words, you're just asking for the hell of it. Well, if it's something you're supposed to have been supplied, it's not something you're asking for the hell of it. You're just asking them to stick to the rules. First-hand witness identification, that can be withheld. Prosecutor is not required to record information or to obtain for the sole purpose of disclosure, as subsection 15, where it's not in the possession or the control or has nothing on record. Section 17 is restrictions on disclosing witness information, witnesses' personal information. The court can say whether or not you can be granted that information or not, just especially in case it might be harmful to the witness or something like that. Section 17 is restrictions on disclosing witness information, witnesses' personal information. The court can say whether or not you can be granted that information or not, just especially in case it might be harmful to the witness or something like that. And I would point out here that in subsections, so that's how that works. That's all your sections of the Criminal Disclosure Act 2008. Summary Proceedings Act is the place you would go to. Summary Proceedings Act 1957 tells you the entire procedure of infringement notices and what you should do, what you should get, and what the rules are with them issuing it. Also about receiving the documents and all that sort of jazz. The Criminal Procedure Act 2011 is where you find out the category of your offences. And Criminal Procedure Act 2011 section 13 is a really nice one, because it says that procedural requirements of this act, regulations and rules to be followed. In other words, they have to follow them. Under section 13 of the Criminal Procedure Act, they have to follow their rules. It's that simple. Filing a charging document under the Criminal Procedure Act 2011 Part 2 section 14 is where you'll find the commencement of criminal proceedings. Tells you basically that where the court is that they should be filing. Section 16 tells you all about the charging documents, and that it must only have one charge on it. It must include the defendant's particulars, the plaintiff's particulars, the prosecutor's statement, charge of particulars if required under section 17, which is the particulars such as in that you drove a motor vehicle, and also it's supposed to inform you of your provisions. Contents of charge, single offence, alternative word can be identified, representative charge must be identified. Section 17.4 of the Criminal Procedure Act 2011 states that a charge must contain sufficient particulars to fully and fairly inform the defendant of the substance of the offence that is alleged that the defendant has committed. So it tells you pretty much right there. Without limitation of subsection 4, the particulars provided must include the provisions. So it's section 17.5a, a reference to the provision of an enactment creating that offence or the offence, and B, if the charge is a representative charge, information specified in subsection 6. Section 18 of the Criminal Procedure Act 2011, a court may make a section 30 order to order the prosecution to get his shit together. Criminal Procedure Act 2011 section 19, the charge can be worded in an alternative, so it doesn't have to be exactly as the provision states. Criminal Procedure Act 2011 section 23, a person commits an offence who includes or directly any other person to include in the charging document any false or misleading information the person knows to be false or misleading. I don't know, perhaps not filling it out correctly is not exactly misleading, but it's certainly not giving me everything I should. Section 25 tells you the time for filing different categories of the offences. Section 39 of the Criminal Procedure Act 2011 is the bit where it records or requires the defendant to enter a plea, and Section 41 is the defendant who refuses or fails to plead under Section 39. So again, not refusing, not failing, not reluctant if you're standing there with with a plea of guilty in your hand ready to sign, supposing after you can be fully informed. That really is a spanner in their works, because they can't do anything about it. So yeah, that's initial disclosure. Pretty simple, and after you get all that, and if they actually get their shit together and do give you all of the disclosure that you're supposed to get, which is highly unlikely, then you can have some fun with the witnesses on the stand. That camera operator, I mean, I've got 50 questions lined up ready, even if it ever gets to that point, although given the fact that in my case it'll be 10 months before I actually even get full disclosure, or they get to even get a plea entered from me, that they've gone over their limit. And bear in mind, on a category 1 offence, they've got a minimum of 6 months to get a plea entered, and they have a maximum of 6 months to start the proceedings and get it underway. In other words, to have a plea entered, and they have up to 12 months to complete the proceedings. So even if we do get round to me being fully and fairly informed and the judge saying we're not going to throw this out, we're going to go ahead and see it, and if she reschedules that time for longer than 12 months, well, justice delayed is justice denied, and I win by default. So yeah, something you guys should always remember is that, you know, a lot of people sometimes, and good on them, do successfully defend themselves at court. You know, for some reason perhaps the witness doesn't shows up for the police, or something happens and the judge will actually find in your favour. Nobody seems to realise that you can charge, I think it's $226 per appearance. So if you've gone to court a couple of times over a matter and then it gets thrown out or you win, there's $500 odd worth of costs that you can claim under the Cost of Criminal Cases Act 1967, and I think the regulations are 1987. So, you know, that I think it's also re-amended in 2013. But yeah, costs in criminal cases. So if you're a defendant that's had it dismissed or withdrawn, depending on the reasons, you could get yourself some dollars. And why not? I'm sure it's cost you petrol, it's cost you time, it's cost you parking, it's cost you food, you know. I'm sure you could have enjoyed a day in a spa instead of sitting in the courtroom. But, you know, why not, if you can, do it. Yeah, that's about all I have to add. Don't want to talk too much and ramble on, although I probably already have already. Have a good one, and if I don't see you before New Year's, it's the 27th today, if I don't see you before New Year's, have a happy New Year's, and I'll catch up with you on the flip side. See you guys.